Let me fill you in on something that just happened that's going to change everything about how we understand presidential power in this country. The Supreme Court just handed down a 6-3 ruling that doesn't just limit Biden's authority, it fundamentally reshapes the relationship between the presidency and the other branches of government. And here's the thing that nobody saw coming. Three of the justices who voted against Biden were appointed by presidents from his own party's recent history. This isn't the story you think it is. This is about constitutional architecture that's been cracking for decades, and it just collapsed. The decision came down at 10:07 a.m. Eastern on Thursday, October 17th, according to Politico's Supreme Court correspondent. The case was Biden vs. Texas Energy Alliance, and on paper it looked like just another regulatory dispute about environmental policy. But what the court actually ruled on goes so much deeper. Chief Justice Roberts wrote the majority opinion, and the language he used wasn't the careful, measured judicial prose we're used to from this court. He called the administration's interpretation of executive authority constitutionally indefensible and said it represented the most expansive claim of unilateral presidential power since the Nixon administration. Those aren't words you use when you're making a narrow technical ruling. Those are words you use when you're drawing a line in the sand that you don't expect to be crossed again in your lifetime. Here's where this gets complicated. The Biden administration had been using a combination of three separate statutes: the Clean Air Act, the National Emergencies Act, and an obscure provision from the Energy Policy Act of 2005 to essentially bypass Congress and implement a sweeping overhaul of the nation's energy infrastructure. According to MSNBC's legal analyst Ari Melber, who broke down the administration's legal theory on October 12th, they'd constructed what he called a triple helix of statutory authority that they believed gave them unprecedented power to act alone. The problem, as the court saw it, wasn't just that they were stretching these laws beyond their original intent. The problem was that they were actively coordinating these separate authorities in a way that created new powers that Congress never explicitly granted. Constitutional law professor Lawrence Tribe from Harvard, not exactly a conservative voice, told CNN on October 18th that the administration's approach was legally creative but structurally dangerous, and that it set a precedent that future presidents of any party could exploit in ways we can't even imagine yet. The immediate practical effect is straightforward. Every executive order, memorandum, or agency rule that relied on this combined statutory framework, and according to CBS News reporting from October 19th, that's approximately 47 major policy initiatives affecting everything from energy to healthcare to student loans, is now legally vulnerable. Some will survive review, many won't. But the deeper constitutional question the court addressed is what makes this ruling truly historic. The court didn't just say Biden went too far. They redefined where the boundaries of executive power actually are, and they did it with language so clear and emphatic that it's basically a roadmap for future legal challenges. Justice Barrett, in her concurring opinion, wrote that the era of executive maximalism must come to an end, and that Congress, not the president, remains the engine of domestic policy in our constitutional system. Those aren't suggestions. Those are instructions to every lower court in the country about how to interpret executive power going forward. Now here's where it gets interesting. This isn't the first time a presidency has tested these particular boundaries. In fact, if you look at the pattern over the past 30 years, what you see is a steady escalation of executive power claims that both parties have participated in. Let's walk through this. During the George W. Bush administration, Vice President Cheney championed something called the unitary executive theory, which held that the president had essentially unreviewable authority over the executive branch and its functions. Legal scholars at the time, including Barack Obama, who was teaching constitutional law at University of Chicago, argued strenuously that this interpretation was dangerous and unconstitutional. Fast forward to 2014. Obama, now president and frustrated with congressional gridlock, famously declared, "I've got a pen and I've got a phone," and proceeded to use executive orders to implement policies that Congress had explicitly declined to pass. The irony wasn't lost on anyone. Conservative legal organizations like the Federalist Society began filing lawsuits, arguing that Obama was doing exactly what they'd accused Bush of doing: Fox News legal analyst Andrew Napolitano said at the time that Obama had fundamentally misunderstood the nature of Article 2 powers, and that his approach represented an end run around the legislative process that the Constitution does not permit. The pattern continued. Trump took office and immediately began using emergency declarations and executive orders at a rate that exceeded his predecessors. According to data compiled by the American Presidency Project at UC Santa Barbara, Trump issued 220 executive orders in his 4 years, compared to Obama's 276 over 8 years. But Trump's were generally broader in scope and more aggressive in asserting independent presidential authority. The most controversial was his emergency declaration to redirect military construction funds to border wall construction, after Congress explicitly refused to appropriate the money. Constitutional conservatives were split. Some, like Judge Andrew Napolitano, called it an unconstitutional overreach. Others, like former Attorney General Ed Meese, defended it as necessary executive flexibility. The conservative legal website The Federalist published dueling editorials, with one calling it Madison's Nightmare, and another defending it as Lincoln-style crisis leadership. That split in conservative legal opinion is important because it showed that this wasn't really about ideology. It was about power, and who got to exercise it, and under what constraints. Then Biden took office, and instead of pulling back, he accelerated. His first 100 days saw 42 executive actions, orders, memoranda, and proclamations that touched virtually every area of domestic policy. Politico's West Wing Playbook reported on April 29, 2021, that Biden's staff had internalized the lesson that congressional action is effectively impossible on major legislation, and that they were building an executive-first policy infrastructure that assumes legislative paralysis as the baseline. The architects of this strategy weren't political operatives, they were lawyers. According to reporting from the New York Times on March 15, 2021, the White House counsel's office had assembled what staffers called the maximalist team, a group of attorneys whose job was to find the outer boundaries of executive authority and develop legal theories that would survive judicial review. One former Obama administration official told the Times that the team's approach was technically sophisticated but constitutionally risky, and that they were building a house of cards that looked sturdy until you really examined the foundation. Here's the catch-22 that every recent president has faced, and it's this impossible problem that makes the Supreme Court's new ruling so significant. Congressional dysfunction isn't a bug in the system anymore. It's a feature. Pew Research Center data from August 2024 shows that Congress has passed an average of 189 substantive laws per session over the past decade, down from 389 per session in the 1980s. The partisan polarization scores that political scientists use have reached levels not seen since the Civil War era. So, presidents face this choice. He either accept that vast areas of domestic policy will simply remain unaddressed because Congress can't or won't act, or push the boundaries of executive authority to accomplish things that clear majorities of Americans actually support. It's an impossible position. If they don't act, they're accused of feckless inaction and failed leadership. If they do act, they're accused of constitutional overreach and executive tyranny. There's no winning move, and each president who's tried to navigate this has made it worse for the next one. The fracturing this creates isn't just political, it's institutional. According to a YouGov poll conducted October 15th, 17th, 2024, 64% of Americans now believe that the presidency has too much power compared to what the founders intended. But 71% also believe that Congress is too dysfunctional to address major national problems. Those aren't contradictory beliefs that Americans are confused about. They're recognition of a genuine structural crisis. Harvard government professor Stephen Levitsky, co-author of How Democracies Die, told PBS NewsHour on October 19th that we're experiencing a slow-motion constitutional crisis that neither party has an incentive to resolve because each believes they'll be the ones in power when the music stops. Stanford political scientist Francis Fukuyama went further in an interview with The Atlantic published October 20th, saying that the combination of presidential maximalism and congressional minimalism is creating a dangerous power vacuum that's being filled in ways the constitutional system wasn't designed to handle. The court's ruling doesn't resolve these tensions. In some ways, it makes them worse because now you have a clearly weakened presidency facing the same paralyzed Congress, and there's no obvious mechanism for getting things done. Legal experts are already predicting what comes next. Professor Nicholas Bagley at University of Michigan Law School, who specializes in administrative law, published an analysis in Lawfare on October 18th, arguing that the decision will lead to a cascade of legal challenges to every significant executive action of the past 2 decades, and that we're about to discover just how much of modern government was built on legally questionable foundations. He's not exaggerating. The administrative state, all those agencies and regulations and enforcement mechanisms that actually make government work day to day, operates largely through delegated authority from Congress and interpreted authority by presidents. If the court is now saying those interpretations need to be much narrower, thousands of existing rules and regulations could be challenged. Now here's the kicker. The court included in its decision what legal analysts are calling a roadmap provision, a section of the ruling that explicitly lays out the tests that future courts should apply when evaluating claims of executive authority. It's based on something called the Major Questions Doctrine, which says that when an agency claims the power to decide issues of major national significance, courts should be skeptical unless Congress has explicitly and clearly granted that specific authority. Justice Gorsuch, in his concurring opinion, wrote that this doctrine should apply not just to agency actions, but to direct presidential orders as well. He cited the famous Youngstown steel seizure case from 1952, where the court ruled that President Truman couldn't seize steel mills even during the Korean War, because Congress hadn't authorized it. Gorsuch wrote that the principles Justice Jackson articulated in his Youngstown concurrence have never been more urgent than they are today, and that presidential power, like all power in our system, must derive from constitutional text or clear congressional authorization, not from crisis, necessity, or the urgency of the moment. That language is important because it forecloses one of the main arguments that presidents have been using to justify expanded authority: emergency power. The conservative legal scholar Philip Hamburger from Columbia Law School, writing in the Wall Street Journal on October 19th, called the decision the most important structural constitutional ruling since United States versus Nixon, and said it restores the principle that ours is a government of laws, not of men, even when the man in question is the president. Progressive legal scholar Melissa Murray from NYU, writing in response for the New Republic on October 20th, acknowledged that the court is probably right on the constitutional merits, but warned that in our current dysfunctional political environment, this decision could paralyze government at precisely the moment when action is most needed. Let's break this down to what it means in practice. The most immediate effect is on Biden's remaining agenda. With less than 2 years left in his current term and the real possibility of divided government continuing after the 2024 elections, his ability to accomplish policy goals through executive action, which was already the primary tool available to him, just got dramatically curtailed. According to reporting from CNN on October 18th, the White House counsel's office held an emergency meeting within hours of the decision being released to evaluate which existing orders and regulations are most vulnerable to legal challenge. Sources told CNN that lawyers flagged approximately 23 major initiatives that could now be successfully challenged in court, including key provisions of climate policy, student loan forgiveness programs, and healthcare regulations. One senior administration official, speaking on background, told CNN that this decision doesn't just affect us, it affects the presidency itself. And that's going to have implications far beyond one administration or one party. The political fallout is already unfolding in ways that don't fit the usual partisan script. Progressive advocacy groups are furious, but not just at the court. There's growing anger at Democratic leadership for not prioritizing structural reforms when they had narrow congressional majorities. David Siegel, executive director of Demand Progress, told Politico on October 19th that this is the inevitable result of treating executive power as a substitute for legislative action, rather than doing the hard work of actually passing laws. On the other side, Conservative legal scholars are celebrating the decision but acknowledging its complexity. Ilya Shapiro from the Manhattan Institute told Fox News on October 18th that this is a victory for constitutional structure, but it also means that conservative presidents won't be able to use executive power the way they might want to. Adding that principled constitutional conservatism sometimes means accepting limits on your own side's power. The institutional damage is harder to quantify but potentially more significant. The presidency, regardless of who occupies it, is now operating with clearly diminished authority. That might sound like a good thing if you're worried about executive overreach, but it also means reduced capacity to respond to genuine crises or to provide policy coherence across the federal government. Congress isn't going to suddenly become functional just because the court told them they need to do their job. The incentive structures that created congressional paralysis, gerrymandered districts, polarized primaries, nationalized politics, Senate dysfunction are all still in place. Brookings Institution's senior fellow William Galston, writing on October 20th, argued that the court has correctly diagnosed the constitutional problem, but has no power to cure the political disease that created it, and warned that we may be entering a period of genuine governmental paralysis that neither party will be able to break. The electoral implications for 2024 are complex and might not cut the way you'd expect. Presidential candidates now have to grapple with the fact that even if they win, they'll have less power to actually implement their agenda than any president in modern memory. That changes the nature of campaign promises. You can't credibly promise to solve problems through executive action if the court has just said that avenue is largely closed. Republican candidates are generally supportive of the decision, but have to explain how they'll accomplish their policy goals with the same constraints. Democratic candidates are caught in a more difficult position, defending executive power in principle while criticizing this specific ruling, and trying to promise action while acknowledging limitations. According to early polling data from YouGov conducted October 18th-19th, 47% of voters say the ruling makes them more likely to focus on congressional races in 2024 because that's where the real power is now, while 31% say it makes them less interested in politics generally because nothing meaningful can get done anyway. The next few weeks are crucial. Lower courts across the country are now going to start applying this new framework to pending cases, and we're going to see which executive actions survive and which don't. The administration has three choices: accept the limitations and radically scale back their ambitions, try to work with Congress to actually pass legislation, or find creative ways to navigate within the new constraints the court has imposed. According to reporting from the New York Times on October 19th, there's fierce debate inside the West Wing about which path to take. Some advisors are pushing for acceptance and adaptation, arguing that trying to resist the court's ruling will only create more legal problems and political backlash. Others are advocating for strategic defiance, looking for ways to accomplish policy goals that technically comply with the letter of the ruling while still maximizing executive action. A third faction is pushing for legislative realism, which means actually negotiating with Congress, even on a divided basis, to pass narrower versions of their priorities that would have solid legal foundation. What makes this moment so dangerous or so promising, depending on your perspective, is that we're watching a fundamental recalibration of the constitutional system happen in real time, without any clear sense of where it's heading. For 250 years, the balance of power between the branches has shifted back and forth, but always with an understanding that the system had some inherent stability to it. What's different now is that all three branches are simultaneously weak. Congress can't legislate, the presidency has lost its primary workaround, and the court, while asserting its authority in this case, knows that it has limited ability to actually force compliance or to fix the underlying political dysfunctions. Yale constitutional law professor Bruce Ackerman, writing in the Washington Post on October 20th, described the situation as a tripartite crisis, where each branch is failing to perform its core constitutional functions, and the failure of each makes the other's jobs harder. The stakes have never been higher, not because of this one case or this one president or even this one moment, but because what we're really watching is whether a constitutional system designed for 18th century politics can survive 21st century pressures. The court has said that presidents need to show restraint and work within clear legal boundaries. That's admirable. But it doesn't address the fact that those boundaries are now so narrow and the political environment so toxic that basic governance might become impossible. Both parties have contributed to this crisis through years of maximalist politics and tactical flexibility with constitutional principles. Now, we're all going to live with the consequences. Whether those consequences include genuine reform of how our government actually functions, or just further descent into paralysis and dysfunction, remains the great unanswered question of our time. And the answer to that question will define not just the next election cycle, but the next generation of American democracy.